Welcome to Raising the Bar podcast,
sponsored by the Ashmore Law Firm.
We're your hosts and siblings,
Gary Ashmore
and Lori Ashmore Peters.
Subscribe so you don't miss a single episode.
Welcome to this episode, and it is a special episode of our Raising the Bar podcast, sponsored by the Ashmore Law Firm with your co-host, Lori Ashmore Peters.
And Gary Ashmore.
Brother, sister, not
Indeed.
husband, wife. We always have to make sure that we make that very clear.
We do.
Okay.
Every time.
So we have our two special guests today and part of the Ashmore Law Firm, and I gotta say, they rock it, and especially this incredible woman to my left, your right. Gary, would you like to introduce?
Yeah, so we've got our managing family law attorney, Hamid Naraghi, over here on the far left, and we've got our lead litigation family law attorney, Desaray Muma.
And I mean, I'm telling you, sorry, but rock star. So I feel a little inferior sitting next to her, as she always has shoes that are just to die for.
Look at those things.
She's always dressed fit to kill.
To the nines.
To the nines, and her glasses are just unbelievable, while I have my little readers that I bought, I think, at Walgreens. So you're making me a little subconscious here sitting next to you. But so today we are going to talk about our family law practice here at the Ashmore Law Firm and just the incredible results that we have been getting for our clients, just so that you guys can understand what kind of an approach we take.
Right.
Here at the Ashmore Law Firm, I'm just going to say we're not your typical law firm. At least I don't think we are.
Correct.
Dad instilled in Gary and I that, relationships matter first and foremost above all else. And we make sure that everyone that works here and every client that comes through the front door really shares in that philosophy, our values, and we get the job done as a team.
And one of the biggest things that we do and we handle, especially on our family law cases, is we take a team approach. And Hamid and Desaray may talk a little bit more toward that, where you're not just hiring one attorney to handle your case. You're hiring the law firm, and you're handling a collective of attorneys and paralegals, and getting both their knowledge and experience, whether it's 3 years experience, 5 years experience, or in Hamid and my case, 25 to 30 years experience. Desiray's got 10, 11 years of good litigation trial, jury trial experience as well. We'll talk about that also. So we think that that's where you are getting kind of a different level, a different approach, and a different level of service. And throughout all that, you're only charged for one attorney who's primarily working on your case and not collectively being billed by 2 and 3 lawyers at the same time.
So for those of you listening right now, you can pick up your jaw off the floor.
Right.
Yes, as attorneys, we are saying you get the collective team, but you only get charged for one attorney.
Right.
That's right.
All right, so Hamid, if you want to kind of start, let's talk about some case results and kind of what the family law section's done.
Yeah, thank you, absolutely. And actually, before we get into the actual cases, I want to expand a little bit on that team approach, because I think it's really crucial to the solutions that are put together for our individual clients. Kind of like you guys were alluding to, law in general, family law specifically, it's not an exact science. It's not 1 + 1 always equals 2. Right. It's really about getting to know the particular client, getting to know their situation, getting to know their goals, their objectives, and really customizing a plan for how to move that case along and get the best solution possible. Now, every attorney, kind of like you mentioned, is going to come with their own background. They're going to come with their own experience. They're going to come with their own solutions. So under that team approach, we always meet at least once a month and discuss all of our cases. We do what's called a file review. During those meetings, we're sharing ideas. Well, this is what's going on. This is what they want. Here's the problem on the other side. Here's where we have a jerk of an attorney on the other side or a reasonable attorney on the other side.
That's right.
So how about if we try this? And we always try to find the easiest, the simplest solution possible. And a lot of times that can happen. But there's times where, look, there's just obstacles. So with that team approach, like you were saying, everybody has the input. The client gets the benefit of all of that cumulative experience, but they only pay for one.
Right, okay. So, and I guess you've kind of instilled in us as well that it's always peaceful settlement if possible, aggressive litigation when necessary. And I think we've lived toward that with all of our cases that we have that come into the firm, right?
And I love that saying.
Yeah, and that comes from, look, after 25 plus years of doing this, and I've done it in every capacity, litigation, mediation, private judge, divorce coach, I've done it all. The one thing that everybody wants is they just want what's fair. You know, very few people come in and they're motivated by revenge or anger. Most people, look, this is not going to be a pleasant experience. A divorce process, separating from family members, it's not pleasant. So all they want is what's fair.
Well,
Right.
but I want to ask, so they want what's fair, and yes, I appreciate that, and I get that, and I mean, I don't handle family law at all. But, you know, we've written articles and blogs on the narcissist.
Yeah.
So when you get to the narcissist that unfortunately is on the other side as the opposing counsel's client, do you think that wanting what's fair is still in that mix, or do you think that...
Actually, I do.
Do
I
you?
do.
Okay.
And here's the twist to that, though. Everybody wants what's fair, but the problem is fair is subjective. To the narcissist, and we can talk about that whole dilemma in the future, but even to a narcissist, in their mind, what they want is fair. It's finding the solution that will satisfy everybody. I always say in settlements, the goal is to find what everybody equally loves or equally hates, but it solves the problem. So the point about everybody just wanting what's fair is that people come in, they want what's fair, they want what they're entitled to under the law, and it's our responsibility as the law firm that's helping them, that team that's helping them, to help them find the best solution to that. Peacefully if possible, aggressively, not only when necessary, but sometimes you have to use that aggression just to communicate to the other side that, look, it can go in that direction. Please don't let me have to do that. Let's not go there. Now that you saw that it could happen, can we please go back to the negotiation table? Sometimes that works.
Right.
And enter Desaray.
Enter Desaray, that's correct.
Our rock star litigator that definitely, I will say, gets the job done, knows every law, just everything. You know
That's
it all.
right.
Oh my gosh. All right, so case results. What has been I'm not going to say the best, best or funnest really doesn't come into play when you're dealing with family law, but also as attorneys, do y'all feel in the family law arena that you have to take the emotion out of the equation? You understand the emotion that the clients are going through, right? But at a certain point, you got to kind of take a step back and take that emotion out of it and tell them, it gets to a point where this is what it is,
right,
and now we just have to move forward and attack it if necessary. Is that fair?
Absolutely. We've talked about it, distinguishing between the two different kinds of divorce that everybody goes through, a legal divorce and an emotional divorce. Well, we're dealing with the legal side of it. We're using the court system. We're dealing with the bureaucracy that you have to go through, the paperwork you have to go through to objectively, most of the time, resolve the financial issues, resolve the asset issues, deal with what's best for the kids. All of that, like you're saying, requires somewhat to be objective. But it doesn't mean that the emotional issues don't matter.
Right.
Those just have to be dealt with in a different way with other resources, whether it's a therapist or whatever. But when we have to present options to them, present solutions to them, then we need them to be as objective as possible.
So I have to ask, with my practice, with estate planning, with probate, with guardianship work, I don't like litigation. That is not my strength. That is not something I love to do. But Desaray, you are a litigator. What is it that you love about it that you don't mind getting in the courtroom? You don't mind going toe-to-toe? And I don't care if it's with opposing counsel that's from a small firm, from a big firm, older, younger, in between. You're meeting them toe-to-toe, nose-to-nose. What is it that you love about that?
I think just rolling with the punches, because you can plan, but at the end of the day, something will go differently than what you expected. So I think just rolling with the punches, and the day goes really fast when you're in litigation. It's like you're coming up for air at lunchtime,
Yep.
And there's some narcissist part of me that are just like doing better than the other attorney.
Of course, that's
And
right.
that's who you want on your side.
Exactly
Without
right.
a question.
And part of it too is, especially if you're going to final trial with a client, you've been their attorney for a long time. I had one case where I was her attorney for 3.5 years.
Oh my gosh.
And I've watched her son grow up. So being an emotional support for them on one of the most stressful days in their life is really fulfilling.
Okay. I mean, that's absolutely amazing. So I know that we do have some cases that we have had incredible results with that we definitely want to, let the viewers know.
Uh-huh.
So how do you want to start about case results?
Actually, before we do that, I got to say something about Desaray since we're talking about it. My office, her office, we share a wall.
Right.
Okay. So and they're relatively thin, so I can sometimes hear some of the things I admire a lot about Desaray. First of all, is she has kind of an encyclopedic knowledge of the law. So knowing the law, she does. Mm-hmm. 2 is that she truly cares about her clients. So when I hear her volume go up, when she's talking to the opposing attorneys on the other side and on the phone or whatever, it's when our client's being taken advantage of. So that's something I admire a lot about her, is that she has to be objective to do her job well. That's part of the reason why even attorneys, the old joke, an attorney who represents themselves as a fool for a client. Mm-hmm. So even though you're a skilled attorney, you have to maintain that objectivity, which is where that joke comes from. But Desaray can be objective, but boy, does she get upset when our client is being taken advantage of. So I admire that a lot, as opposed to this is just a job and I just do it. 3 is that competitive nature of hers. So on those cases where peaceful is not working, and now this case has to go in front of a judge or a jury, and we'll talk about that distinction in a minute, she does not like to lose, and boy, she does not.
And that's what I want in my corner. Oh my gosh.
Right. No doubt.
That's exactly what I want, in addition to the shoes, the dress, the glasses,
The glasses,
everything.
all of it. Okay, so results. Get us into some of the cases that we've had in the past that we've been successful on.
I think there's 2 of them in my mind that I'd like to talk about. Obviously, we can't share names, so we'll just call them, Client A. Client A was a person, and that peaceful solution, if possible, it's not possible. That one's not going to work on this one.
From the get-go? I mean,
Yeah,
did we know,
pretty
we knew that
much.
from
Would
the
you say,
get-go?
Desaray?
Yeah.
Pretty much. That was just not going to work. And it wasn't just because of our client. And I'm not saying that just because it's our client. But
Right.
there was just bad blood between these two. And it had evolved to the point where this was not going to go well. Another important thing to bring up on that is that we were not his first attorney. We were, I believe, his third attorney, weren't we?
We were.
Yeah, we were the third attorney, which is something that happens to our firm a lot. For some reason, when people are not being represented well by their attorneys, they eventually find us, and we handle what other attorneys couldn't handle well. But by the time the case had come to us, there was so much bad blood between not only the parties, but then the lawyers back and forth, that it just wasn't going to settle well. And the history of it had evolved to the point where this case was going to go to trial. But in Texas, you have the option of whether it's going to be a jury trial or just a judge hearing it. That's not the case in every state. In certain states, for example, California, where I used to practice, you don't get the option of a jury trial. Well, how do you pick one versus the other? And Desaray made a very good suggestion on that one, if you want to kind of elaborate on that.
Sure. So we were actually in a file review. We do our file review by Zoom. And we get a new filing from opposing counsel, and it is a suggestion of pregnancy. So wife, we represent a husband, wife had gotten pregnant in the middle of this case that had been pending for 3 years. Mm-hmm. And so that unfortunately stalls the case. Okay. And that's kind of where the team approach comes from. So you'd suggested bifurcating the case, mm-hmm. And the judge went for it. So you can't finalize the case until a child is born. But we wanted to get this out of the way because our client is very successful, and every day he's acquiring new community property.
Yeah.
So doing a jury trial was advantageous because she was 7 months pregnant. And that just came across very poorly to the jurors, I think.
Right. Yeah. Okay.
Yeah, and to your point, we bifurcated it. This case was going to be going on for a while because of this pregnancy, and this was a very high asset high income case. So every month that was going on, that was something that obviously, the pregnancy, I don't know, could have been planned, could have not been planned, but strategically it was to our client's disadvantage for this case to keep going and going and going. But also during those file reviews, you had brought up the suggestion because once a judge is assigned to a case, a judge is assigned to a case. So you're not going to be able to say in the middle of a case, you know what, I want to switch judges. And through the history of this case, the argument could be made that maybe our client was not in the best favor in front of this judge. So we felt uncomfortable, Desaray felt uncomfortable giving all the final decisions to one particular judge to decide, as opposed to being able to select a jury and having that jury decide the case as opposed to that one judge, right?
Right.
Yeah.
And that's great strategy and something that, you always have to consider.
Right.
Because unfortunately, we're all human, and there are times where, a judge may not feel, warm and fuzzy about your client, depending on the situation.
And I don't totally blame this particular judge because leading up to a final trial, you have temporary orders hearing, and there were multiple temporary orders and enforcement hearings. So she's getting a little snippet. She's not getting the whole story. Mm-hmm. And we were able to tell the whole story to the jury start to finish. And so because they got the whole picture, they had a much different outcome, I think, than the judge.
Okay.
And that's important because it is a jury of your peers, and you're selecting from 12 strangers, and you're able to present your case to them in the light that you want to present it, obviously in your client's favor.
Right.
And it's not to a judge who has heard all of the back and forth through all these temporary orders. They've heard all the squabbling. They've heard the good, the bad, and the ugly. And it truly kind of levels the playing field. So then it is a jury of your peers making that call and that decision on those issues.
That's
and
right.
I think that that's very important.
So is it 12 jurors?
Uh-huh.
It's 12.
It's 12 jurors, and how many do you need to vote in your favor to win?
10.
Okay. Wow.
Yeah.
That's a lot.
And in our jury, we had one holdout.
And what does that mean?
She didn't agree. The other 11 agreed.
Oh, wow. Okay.
But all we need is 10.
All you need is 10.
And picking the jury is really important too. So on this case and my other jury trials, we use a jury consultant who's a psychologist, and so he's reading body language and different cues from people, and also getting the key demographic. So in the jury picking process, we get to ask them questions, and they fill out questionnaires. So we want to know: do you have kids? Have you been divorced? How did that divorce go? Were you burned in the divorce? That sort of thing.
Okay, it's a science. Would you say jury selection is a science?
Yes, it is. Absolutely.
Yeah, it's an art, it's a science, and that's one of the things where I'm going to get her to keep blushing on there because I'm talking so good about her. But she really is skilled and experienced. Those are two different things. Statistically, you have to understand that a lot of family law cases settle before they go to a trial. Jury trial or a trial in front of a judge. It's called a bench trial. But statistically, 90% of cases settle before they actually go that far. So what will happen is you get attorneys who have been practicing for a long time, but some have never gone to an actual trial. Some have gone to very few trials. And you definitely have a lot of attorneys who may have gone to trials, but not jury trials. Well, the experience matters, which is one of the reasons why so many clients who have former attorneys, their cases aren't settling, now they feel uncomfortable with their attorneys, and they get referred to our firm, and Desaray handles their case and wins. But even between a judge trial and a jury trial, it's a different skill set there. It's different arguing to a judge who's an experienced attorney, an experienced judge, used to hearing arguments in a different way, versus handling a trial in front of a jury. Like you said, these are members of the community, your peers. Everything has to be explained to them in a different way. You get to play on their emotions a little bit more. So it's a completely different skill set. And God forbid if I'm ever in that position, that's who I want as my attorney.
Right. Okay.
So what's considered a win? That's very subjective, right?
Absolutely.
It depends on each specific client, but if a client has, 20 different things that they want, because I'm assuming that's kind of how that's how you break it down.
Yeah.
Like they have all of these asks of what they want to accomplish, and then you present that and you hope you get all 20, of course.
Right.
Statistically, if you're going to get all 20, I mean, I'm sure that's uphill.
Right.
But so what do you consider a win?
Well, it depends on the client, and it's important to know what is most important for your client and to leverage for that. So in the case we were talking about, it was very important to get the right date of marriage, because that determined what was common law property and separate property, and what could be divided by the court.
Okay.
So when we won that, everything else pretty much fell in place.
Okay.
Right.
For other people, it's just about...
But wait. I need to back up for a second. How do you not know the date of marriage?
That's
I
a good
got
one.
married on September 30th, 1995. That's when
Right.
we said I do. We signed the piece of paper. How is that in question?
So they
I
got...
don't know. Isn't that the reason why men forget their anniversaries?
That's right.
Isn't that one of the reasons for divorce?
Right.
You forgot my anniversary?
So this couple got married in Mexico. Now Mexico has their own requirements for creating a legal marriage, which they did not do. So they were trying to say that they were common law married at that day. Later on, after that, they went to Denton and did a ceremonial marriage, like what you've had.
Right. Got it.
Yeah, so they were trying to argue that they were common law married because they lived together. They're arguing that they lived together as husband and wife, that they agreed amongst each other to be married during that time, and that they represented each other as married to other people.
Okay.
And we were able to disprove that.
Oh, see, and so I think that's a misconception of common law, because you always hear, oh, if you live together, if you have a toothbrush at each other's at the place, then you're common law married, but that's not quite the case.
Well, remember I said encyclopedic knowledge of the law?
It
There are
does,
times
yeah.
where I can either go do research or I can go ask Desiree.
Right. That's right.
And I
Which
asked
do you
Desiree.
choose?
Well, we have that thin wall between our offices, remember? Hey, Desiree?
Desiree. Okay, and that was a successful case. I mean,
Yeah,
you got
but
past that
I also
first
want to
priority.
kind of contribute to that whole what's a win?
Mm-hmm.
Well, when a case has to go all the way to a trial, a win or a loss is relatively easy. Okay, you present an argument, the judge or the jury either rules for you on that issue, you won, or they rule against you on that issue and you lost. But remember that our motto was peaceful settlement if possible, aggressive if necessary. The litigation, the trial should only happen if it's necessary. There's, to some extent, the first part of that, the peaceful if possible, that suggests that if your case has gone all the way to trial, to some extent you've lost. Everybody's lost. The emotional cost of going through a divorce all the way to a trial, the financial cost of going all the way to a trial, the disruption. To some extent, look, especially if you have children, after the divorce is finished, the family continues. The role as husband and wife may have ended. The role as mom and dad doesn't end. As a matter of fact, it's going to evolve into grandma and grandpa, right? So if a case goes to trial, to some extent, everybody's lost because damage has been done. Mm-hmm. But unfortunately, sometimes it's necessary.
Right. So in the case that we talked about, I know you'd mentioned that the wife got pregnant. I guess share with everyone, was the pregnancy from the ex-spouse or the...
It was not from our client.
It was not from our client. All right.
This was actually the second boyfriend that she had shacked up in my client's separate property home during the case, during the 3 years
Right.
this divorce was pending, sleeping in his bed.
Yep.
So
All right. So just
There
to
were some hurt
clarify
feelings.
that. Right. There
Just
yes,
a little
yes.
bit.
And we don't have to use allegedly anymore. You know, you always have to say allegedly. No,
Allegedly.
this was litigated.
Right. That's right. We know for sure now. That's right. Okay.
So I know what definitely sets us apart from, most of the other firms out there is the team approach that we do take. But, again, not handling family law, but handling the other areas, I know how important it is to manage a client's expectations. Mm-hmm. And I think that we do that beautifully, even on the family law side of things, right?
Managing their
as possible.
expectations is one. Bedside manners. Look, we make it a point, and we do this not only in your jobs as the firm owners of who you bring onto the firm. You don't hire everybody you interview. You hire people who are good at what they do, but they're sensitive to the subject matter that they're helping people with. We have to remember, this isn't just the case, these are people. Mm-hmm. These are emotions, and we have to be sensitive to that. You do that by giving the best representation possible, but having the bedside manners to communicate with your clients consistently so they always know what's going on in a sensitive and sometimes tough love approach. You have to give them the good news, you have to give them the bad news. You can't sugarcoat everything, but you have to be sensitive about it. And between the team, look, there's different personalities, right? Sometimes people get better or get along better with different personalities. Under that team approach, it doesn't matter. You may have one attorney representing you, being at court, but you may connect with another attorney, so that attorney always talks to you, explains things to you in a way that you can understand, because ultimately you have to know what's going on and why.
Right.
Which, man, that is so important. I wish they did teachers that way.
Yeah, no, they don't.
When they're teaching
They don't.
subjects, right.
All right, so what's another case result that we've had here recently?
Do you want to talk about that non-jury trial? Kind of distinguishes it?
Sure.
Yeah, go ahead.
So I represented father in a divorce, and that took forever. And he came back to us at this firm because mom had filed a modification, and she was alleging that the children were in danger with dad, and made all these allegations that he wasn't bathing them, et cetera, et cetera. So in the divorce, she ran through two good attorneys. And at that trial, she was pro se. So she represented herself, and it was a zoo that day.
Right.
We ended up getting a great result for him because in that county, the associate judge hears all the temporary orders hearings, and we won all the temporary orders hearings.
Right.
So we didn't need a jury trial.
Right.
And in that particular case, she had just won the district court judge. So she heard everything as associate judge, and now she's hearing the final trial as a district judge. So it was very convenient for us. So anyways, she files this modification. He hires us again. And this woman is crazy. I mean, she's just bonkers. And everything she asked for, she didn't get. She hired an attorney. They fired her. They withdrew.
The attorneys fired the client.
Well, in the pleadings, you don't know, but you can tell.
Yeah.
You're not allowed to say.
But
Allegedly.
She hired another attorney, and that attorney withdrew at that first hearing. And she didn't show up for that hearing. That was her hearing.
Right.
And she hired another attorney. They fired her, and then they got back on the case, and then they got off the case again.
Right.
So at final trial, she was going to be representing herself, and we chose that final trial to be a bench trial where the judge hears things versus a jury, because we knew that everything had gone in our favor.
Right.
So she had asked for custody evaluation. Well, in the previous case, she never did the intake paperwork for that, and it was a waste of our client's money and time, so the judge said no. She wanted to go to mediation and ask that be waived. Normally, the courts make you go to mediation as a way of getting rid of some of their caseload.
Right.
And it's very unusual for the judge to waive that. But we brought up, hey, in the divorce, she didn't show up to mediation, judge. And so at the end, our final trial in front of the judge, she didn't show up.
oh my gosh.
But we
all
put
that.
a
After
pretty
all that.
extensive record on the record so that if she did file a motion for new trial within 30 days, that we were covered.
Yeah.
Right.
So two actually really important things to bring up on that. First of all, Desaray mentioned this was in a different county. Our office is situated in Dallas County, but this was in a different county. And that's something that our firm is very good at, is we have experience in the counties that are surrounding our office. And that's important because every county, not only do they have slightly different procedural rules that we have to be aware of, two is, look, every judge is going to handle their case a little bit differently. Every judge comes with their own background, knowledge, experience that, they get some discretion. So we have experience, and Desaray and the other attorneys here have experience in different courts, so they can handle that well, which she did. Two is, you notice that in this case, as opposed to the other one, the judge all along during these motions and these little pre-trial hearings seemed to be going along with our side. So now we wanted to keep that judge, as opposed to the other one where we didn't want this judge making the final decision. On this one, we wanted the judge. So that kind of goes into the strategy of if this case is going to go to a trial, do we want it in front of a judge or a jury? And we don't want to guess. We want a plan that goes along with that. So, and it paid off.
Right.
And I imagine it's so important, the judges have so many cases, especially in family law, that they're dealing with.
Right.
I mean, all judges do, but, in family law, they've got so many little nitpicky things that they're dealing with, and some of them are legit, right? And some of them aren't. But when you have a judge, does a judge review the file from beginning to end before the hearing to actually know what the issues are and what has gone on? Or are they just hearing that one little snip?
It really depends on the judge.
Okay.
Some judges are really good at what they do. For example, in Tarrant County in the child protection courts, those judges, the associate judges, review the entire file before every case.
Oh, wow. Okay.
Because the child's life is on the line.
Absolutely.
It's
Right.
not just people
Right.
bickering.
Right.
But there are other judges who just really don't care.
Okay.
And so it's important to know the judge and know that that's happened, because you might want to start with, judge, as you may remember at the last hearing, blah, 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 and get them up to speed because they're not up to speed.
Right.
Okay. And that takes mastery in and of itself. It's number
Right.
one. Obviously, to know your judge and know how they are, but then also to be able to bring them up to speed quickly,
Right.
concisely.
Which goes back to the advantage of our firm having worked and continuing to work with the different counties and in front of the different judges, because you don't fall into a groove. You don't handle every case the same way.
Right.
You have to not only customize it based on the client's needs, their goals or objectives. Look, what evidence do we have? How do we use that to our advantage or the other side's disadvantage? But also, which court are we in, and how do we present this case? Now, look. Gary, you and I have been doing this for a long time, and actually your father was a judge, right? The cynical side of me says this is a judge. Judges don't care. Look, they're not prepared, they don't review it. The reality of it is, look, the courts are overwhelmed. They have how many cases every morning? How many of those cases would they review, but they actually settle and they don't even have to go?
Right.
So the practicality, you have to take that in fact. This is not a jab against judges. They do fantastic work. But the bottom line is your attorney needs to know the distinction between this is a judge who reviews cases, so maybe I need to write the motions differently, or this is a judge who doesn't, so my energy really needs to go into oral presentation of the case.
Right. And that's very important. That's
Right.
correct. That's correct.
And just to be able to read all of that.
All right. Any other results that we wanted to talk about?
Yeah, one that highlights the importance of the team approach. You notice that we've talked about from the beginning of a case, we all collaborate on cases. All the attorneys here, we talk about them, we're aware of what's going on. Each attorney is not just an island, which is what happens a lot in other large firms or other even medium-sized firms where you have more than one. Because we collaborate, look, the reality is sometimes your attorney won't be available when a motion or a trial is scheduled. Trials are scheduled out, months ahead of time sometimes. And in this one particular case, where if you want to talk about that, Desiree,
Sure.
where you couldn't show up for the trial.
I couldn't. I was in a jury trial for 12 days in another county, and we were only scheduled for 5.
Right.
And no one expected it to go that long. Opposing counsel didn't expect it to go long. The judge, we had to stop and take a few days off because he
Right.
had a trip to Mexico planned.
So a 5-day trial ended up being a 12-day trial.
12-day trial. And I was scheduled on the following Monday to do another trial in Collin County.
Right.
And so we sat down with the client beforehand and said, if it runs over, and of course, I thought it was just an if at that point. We really didn't expect it to go that far. We gave her the choice, would you rather move the trial out and me continue to be your attorney for the jury trial, or would you want another attorney, Samantha Matthews, who's an associate attorney here?
Right.
And she
Who's
said,
also a great lawyer.
yeah.
Yeah.
And she said, I trust your team. Whatever you think is best. I think I don't want to postpone this.
Right.
So I'm comfortable with Samantha. And it was also advantageous because we really didn't like that judge. And there was a visiting judge for a couple months. And we knew that by the time we reset it, we would be back to the old judge. So
more strategy.
yeah.
It's all very strategic.
Yeah.
And I was ready to do that case. I was kind of upset that I couldn't do that case. So he eventually, he went through 2 attorneys. They both fired him. He was going to do it pro se. And he actually ended up settling the last minute. I guess he was afraid. He thought it was me coming.
That's right.
And it was exactly what the client wanted. And we'd actually offered a much better deal at mediation. He turned us down.
Yeah.
So it was a really good outcome for the client. We saved her some money because he folded at the last second.
Right.
We didn't have to postpone things.
Which might not have happened, which probably wouldn't happen. I'll go farther. Would not have happened if, because you weren't available, because now you were stuck in a 5-day trial that ended up being a 12-day trial, that case would have had to be continued. Instead, because of that team approach, the new attorney, the Samantha Matthews, she didn't have to learn the case. She was already up to speed on the case. So it was like, you know what, someone else is going to handle this very well. Of course, the client got to choose, but she was comfortable because she had talked to all of us. She knew that we were all aware of it. So we didn't miss a beat.
Right.
And it put the other side at a disadvantage.
Yep.
Well, and the beautiful part again about the team approach is whenever a client calls in, it doesn't matter if the attorney is in trial or out or in a meeting.
Right.
They can talk to any of the other family law attorneys. They can
Right.
talk to the family law paralegals, and they're going to talk to someone
Yeah.
to either get their questions answered or at least talk to someone that can get to the attorney or one of the attorneys quickly to get their question answered. And they're not waiting, 48, 72 hours, a week, 2 weeks for a callback.
And one of the advantages of me being the managing family law attorney means I don't go to court. I'm managing our department. Is I'm almost always at the office. So they can always get in touch with me, even if all the other attorneys just happen to be in court or depositions or somewhere else that requires them to be away from the office. So I'm always here. Two is because of my background as a divorce coach, I'm very good at talking to someone who's understandably upset, nervous, anxious, excited, and I'm very good at talking to them and explaining things to them in a way that they can understand. One of our rules over here when a client discusses a case with us or ends up being a client of ours is they're not allowed to worry unless we tell them there's something to worry about. So by calling our office, their minds do that. All of our minds do that when we're involved in a problem, is you always start to think worst case scenario, and if this happens, then that happens, and that happens, then the other thing happens. By calling the office, they talk to me. That doesn't cost them anything extra.
Right.
So they get to talk to a divorce coach who explains things to them, and 99% of the time, there's nothing to worry about.
Right.
If it's that 1% of the time where, there is something to worry about, then at least we talk about the solution.
Yep.
Well, and that's the listening part that's
Yeah.
so important because you do. I mean, unfortunately, you've got some attorneys that will tell the client what the attorney wants to tell the client.
Right.
And they, they don't really listen to what the client is saying.
Yep.
And this goes back to the two of you. The kudos goes to the two of you because ultimately this is your firm. And that selection process of who you hire for this firm, it not only has, of course, they have to be skilled. Of course, they have to be knowledgeable, but they have to be human. They can't leave their human side at law school.
Right.
When they graduate and they start practicing law. And this job can make people cynical. This job, has a high burnout rate. When you're dealing with law, when you're dealing with family law specifically, you see a lot of people a lot of attorneys who after a while, this is just a job, I just got to do it, I got to get out of here, I'm not thinking about it again. That doesn't happen here. We also, in addition to supporting our clients, we support each other a lot. There are days where, I'm having a bad day and Desaray, everybody else here, they come and take care of me. When they're having a bad day at court or whatever, we take care of each other. That keeps us human, and the client is the benefactor of that.
Right. Right.
Don't you miss it?
I do.
Do you miss it?
No, not really.
For those of you, Gary did family law
I did.
a lot, courtroom
did.
a lot for many, 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 many years, although he's only 29.
No, that's correct. That's right.
You don't miss, you miss a little bit. The strategy, the fun.
I do. I miss the fight. You're right.
fight,
Right. I know what Desiree
have a
is
certain
experiencing.
drive
And
for it.
I know why she enjoys it. Absolutely. Of course.
That's why we're completely opposite, because
Yes,
I
we
do
are.
not enjoy any part of that.
Right. Okay. Anything else y'all want to get into? What, just on a side note now, because he'll edit stuff out. Anything we want to cover, any other case results specifically you want to get into? Desiree, anything else you want to share that we can talk about?
I don't think so.
I can't think if there's anything else you think that people should know about us, maybe something lighter or something.
So, well, wait, I don't know
You
if
wanna
this
use the
is
California
right.
thing, or-
Well, and I think we've done articles, I know you've done, I think, videos on this, but, you talked about the divorce coach side of things.
Yeah.
And, you've got a lot of folks out there that think if you already have an attorney, then you can't talk to anyone else.
Right.
What is that?
What is a divorce coach?
Well, what is a divorce coach? How do you fit in? Are you
Well,
able
so-
to talk to?
so yeah.
I mean, when someone's represented by an attorney, what can you do if they're not happy with that attorney?
Right. So one of the misconceptions is that you can't ever get a second opinion. And that's just not true. You can get a second opinion, just as you would your own family doctor or you're going into surgery, you're going to want to get 1, 2, or 3 different opinions. And a lot of people that we've now represented because they're on their second or third lawyer
Right.
come to us and say, well, I didn't know I could switch lawyers.
Right.
So talk about that a minute, that yes, you can in fact switch lawyers. And if you're not happy or your lawyer's not listening to you, then yes, you need to talk to somebody else because you need to get the representation, number one, that you deserve, and number two, someone that's going to listen to you, which I think is huge, and number three, that's going to truly fight for your interests, right? So what else would you add to that?
Yeah, well, I kind of take it a little bit above what you're saying is you can get a second opinion. I'd say you should get a second opinion. Not every case, if it's a simple case and it's going down very amicably and you guys are solution oriented, everything's fine, you don't need a second opinion necessarily for that. But if you're hitting obstacles, if this case is dragging on too long, if you're hearing things from your attorney that, look, in your gut doesn't make sense, then you need to reach out to another lawyer. We do that a lot for people, where you just say, look, this is what's going on. Can you give me your impression of it? That's where my skill as a divorce coach, along with Desiray's experience in the courtrooms here in the Dallas-Fort Worth area, comes in. So we talk to them. Yes, on the case, we want to know if the plan, if they have a plan, but if the attorney has a plan for this case that's consistent with not only what the client wants, but is it obtainable? Sometimes
Right.
what you want is not obtainable because we don't have the evidence or the law is not on your side in that particular situation. And the client may be leading them down a prim path and they may be wasting their money, wasting their resources. Two is a lot of times, like you mentioned, attorneys are good communicators, but in a very slight way. They're good communicators to a judge, to a jury, to a non-emotional trial brief style of way. But they may not be good communicators in taking complex legal concepts and explaining it to the client in a way that they can understand. It's their life. Remember, it's their life, not ours.
Right.
They need to know what's happening and why. No Latin allowed. Don't
Right.
impress the client with, re ipsa loquitur and stuff like that. None of that stuff. So that's an important thing. If you have question marks and if your questions are not being answered to your satisfaction, get a second opinion. Isn't that what you do when you go to a doctor?
Absolutely.
Isn't that, let's go beyond that, a plumber. If a plumber comes to my house and tells me something that doesn't sound right, I'm getting a second opinion. Side note, I had an AC issue last summer.
I was going to say HVAC is the biggest one.
The first professional that came out told me my AC was shot, $20,000 quote. The second opinion came out, he was there for a half an hour, solved it for $500.
Right.
So if it happens over there, don't you think it's important to happen in a legal sense, in a family law
Absolutely.
matter?
Right, and it does.
That's a great analogy.
Yep.
I mean, that hits home.
All right.
Right.
Okay, what else do we want to talk about? Anything else we want to bring up? Touch on?
All good?
I can't think of it.
Okay.
How do
Well,
you-
and again, we ought to do this once every 6 weeks, once a month, every couple of months.
Yeah, Desiree
just
would
to
love
kind of
that.
catch it. Desiree would love it. We'll get you comfortable.
I just want to say, with our podcast being named Raising the Bar Podcast, brought to you by the Ashmore Law Firm, I'm going to answer how our family law department raises the bar. I mean, just listen to this podcast. The team approach for the clients raises the bar. Not paying to have 3 attorneys in a meeting, only paying for 1 attorney raises the bar.
Indeed.
Listening, bedside manner. I mean, all of that truly raises the bar for our clients. And our clients are our number one priority. and it's making sure that their best interest is protected as much as possible. So for me, that's how our family law team raises the bar, without a doubt.
Thanks to our sponsor, the Ashmore Law Firm.
We specialize in probate, estate planning, family law, guardianship, personal injury, and civil litigation.
You can find us at ashmorelaw.com.
Or by calling us at 214-559-7202.
Again, that's ashmorelaw.com.
Or calling 214-559-7202.